State of Utah versus Tyler James Robinson. Could you state your name?
Tyler James Robinson.
They say justice is blind, but inside one Utah courtroom, a single outfit might shape the fate of Tyler Robinson, the man accused of shooting conservative activist Charlie Kirk at UVU last September now faces a new battle before the trial even begins. Should he appear before the jury in normal street clothes, or in the jail uniform that silently labels him guilty before he ever speaks? It sounds trivial, but this decision strikes at the core of the American justice system itself. Fairness, security, the presumption of innocence. And beneath it all lies one haunting question: how much does appearance influence justice? And how far should the courts go to protect it? This is the Tyler Robinson case. And this is EWU Crime Beat. If you're new here, hit subscribe and turn on notifications, because what happens in this courtroom won't just affect one young man. It could reshape how every future defendant is seen and judged.
We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters.
It started quietly. No drama, no headlines, just a routine filing slipped into the Utah County court system. 2 weeks before his next hearing, Tyler Robinson's defense team submitted a motion, not about new evidence, not about witnesses, not even about guilt or innocence. It was about clothing. They asked the court to let Tyler walk into the courtroom in ordinary street clothes, a simple shirt, pants, maybe a jacket, instead of the unmistakable jail-issued uniform he'd worn in previous appearances. And their request didn't stop there. They wanted him unshackled. No handcuffs, no chains, no metal clinking with every step. To most people, that might feel like a minor detail, but in the world of law, perception can be deadly. Because when someone enters a courtroom in an orange jumpsuit, something happens in the human mind. The presumption of innocence quietly starts to erode. Before any testimony is heard, before any evidence is shown, a silent verdict begins forming in the jury's subconscious. Tyler Robinson's attorneys understood that, and they argued that their client deserved what every defendant in America is promised: the right to be seen as innocent until proven guilty. This wasn't about comfort. This was about the Constitution, and about fighting the invisible judgments that can decide a man's fate before the trial even begins. The motion didn't just get noticed, it ignited attention, because it struck a nerve buried deep in the American justice system. The constant tug of war between fairness and security. Every defendant deserves a fair trial. Every courtroom must protect its officers, its witnesses, and the public. And when those two principles collide, the system starts to strain. Robinson's defense team pointed to the Brian Koberger case, another explosive murder trial where the judge allows the accused to appear in normal clothing. The reasoning was simple and powerful. You can't let a jury or the public decide guilt based on a jumpsuit. But Tyler Robinson's situation wasn't the same. He wasn't standing before a jury. This wasn't a trial. It wasn't even close. It was just a preliminary hearing, one procedural step in a long path ahead. And that's exactly where prosecutors drew the line. They argued that, unlike Koberger, Robinson posed a genuine security risk. They insisted there was a legitimate reason for the restraints, and for keeping him in jail attire. The evidence behind that claim, completely sealed, hidden from the public eye. But the message was unmistakable. The sheriff's office saw Tyler Robinson as a potential threat. Now the judge was cornered with a decision that went far beyond what clothes a defendant wears. A decision that could set a precedent shaping courtrooms in Utah and across the country for years to come.
And Chad Grunander on behalf of the state.
Your Honor, Kathy Nestor, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Thank you. Welcome to both the prosecution and defense. Mr. Robinson, I understand, is appearing by WebEx. Mr. Robinson, can you hear us?
Yes, I can.
Thank you. Good afternoon to you all. We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters. The first, Mr. Robinson's motion to strike the sheriff's response. The second, Mr. Robinson's motion to appear in civilian clothing and without physical restraints. The third, the sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing, if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion.
When the defense filed their motion, the pushback didn't just come from prosecutors. It came from the Utah County Sheriff's Office, and their response hit like a warning shot. They raised alarms about public safety, transporting an inmate across county lines, controlling risk inside a crowded courtroom, protecting deputies, staff, and even Tyler Robinson himself. According to the sheriff, this wasn't about optics. It wasn't about humiliation. It was about keeping people alive. But Robinson's attorneys didn't flinch. They fired back, arguing the sheriff had no dog in this fight. Their point was blunt and constitutional. A defendant's appearance in court is a legal issue, one that belongs to the judge, not to the jail. But the sheriff's office wasn't budging. They reminded the court of one undeniable fact. Once someone is in custody, their safety and the safety of everyone around them is the sheriff's responsibility. Judges can write orders, but sheriffs are the ones who have to enforce those orders in the real world. And when enforcing them involves chains, handcuffs, transport vans, and uncertain threats, every decision carries real consequences. Consequences that can be measured in injury or death.
Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 Sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. The court took under advisement two issues: the motion to strike and the motion to appear in civilian clothing and without restraints. Court now issues its ruling. In regards to the motion to strike the sheriff's response, the prosecution and the sheriff's department filed a joint opposition to the defendant's motion to appear in civilian clothing and without restraints. Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party. At the hearing, all agreed that the sheriff's department is not a party in this case. The state and the sheriff's office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the sheriff's department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, defendant's motion to strike the sheriff's response is granted. However, under Rule 3-414 of the Utah Rules of Judicial Administration, the court is required to coordinate courtroom security with the sheriff's department. Consistent with that rule and with the defendant's agreement, the court has considered the substance of the state's opposition and the memorandum prepared by the court security director that was attached to it. Going forward, if either party has a security concern specific to this case, they may present evidence from the sheriff's department by affidavit, declaration, exhibit, or testimony. This order does not limit the sheriff's department's ability to coordinate with the court or otherwise act as authorized by law. Turning to the motion to appear in civilian clothing and without physical restraints. The parties agree that during trial, a defendant has a right to appear in civilian clothing and that any restraints must be concealed from the jury. Mr. Robinson now seeks to extend those rights to all pretrial proceedings. The court considered each request separately. In relation to requests to appear in civilian clothing, Mr. Robinson asks to appear in civilian clothing at all pretrial hearings. He argues that the extensive media coverage of this case creates a real risk of prejudice if the public and potential jurors repeatedly see him in jail attire. The state, the sheriff's department, and the court security director opposed the request, arguing that jail clothing assists with safety and identification. The court has balanced these competing concerns. The case has attracted extraordinary public and media attention. Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt.
By now, this motion had grown far beyond a simple legal request. It had become a constitutional flashpoint, and it was drawing national eyes. Reporters began noticing something unusual: sealed filings, closed-door discussions, whispers in courthouse hallways, and then came the confirmation. The judge announced an in-camera hearing, a private proceeding. No public, no cameras, no press. Behind those closed doors, the conversation would almost certainly revolve around one thing: security. How Tyler Robinson would be transported from jail to the courthouse, which routes deputies would use, what layers of protection would be necessary. The secrecy made sense. Revealing tactical security details could put real lives in danger, but silence breeds questions, and the speculation exploded. Why was the sheriff's office so alarmed? What threat were they seeing that the public wasn't allowed to know? Was Tyler Robinson considered dangerous to others, or was someone else considered dangerous to him?
To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Defense counsel is directed to coordinate with the jail to ensure that this order is implemented, and the court further orders that if the clothing be provided 72 hours prior to any hearing. To the second request to appear without physical restraints, Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. Rule 3-14 sub 9C of the Utah Rules of Judicial Administration requires that all in-custody defendants be restrained unless otherwise ordered by the court. The court recognizes that Mr. Robinson has no criminal history and no record of misconduct while in custody. However, the charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority. The emotional nature of these proceedings also raise the risk of disruption. Given these factors, the defendant's request to appear without restraint is denied.
Tyler Robinson's name carries weight and controversy. He's accused of shooting and killing Charlie Kirk, a high-profile political activist whose influence reaches millions. The case has already split the country. Online, emotions are volatile. Some insist Tyler is a cold-blooded killer. Others argue the evidence is far from settled. Most people just want the truth, but in criminal law, public emotion isn't just noise. It shapes real-world risk. Sheriff's deputies worry about retaliation, about what could happen during a transport, or inside a packed courtroom. All it takes is one moment, one open doorway, one person trying to make a point, one split-second mistake. In many counties, the jail connects directly to the courthouse. Short walks through locked corridors, but not here. In Utah County, Tyler Robinson must be driven from Spanish Fork to Provo, a public route, in a marked sheriff's van, on a day when everyone knows exactly where he's going and when. This isn't paranoia, it's the reality of logistics, and every deputy assigned to that transport knows the stakes couldn't be higher.
The court directs the Sheriff's Department to conduct an individualized assessment and use the least restrictive restraints necessary to maintain safety. If those restraints impede the defendant's ability to communicate with counsel or take notes, counsel may renew the motion. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom. In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. In conclusion, the court orders as follows. Defendant's motion to strike the sheriff's response is granted. Defendant's motion to appear in civilian clothing is granted. Defendant's motion to appear without restraints is denied. The standing decorum order will be amended to prohibit any visual recording or photography of the defendant's restraints or of the defendant entering or exiting the courtroom. This constitutes the order of the court, and a written order and ruling will be published shortly. Both defense and prosecution have stipulated to vacate the October 30th hearing. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues. And that concludes the order of this court. Counsel, thank you for being here. Mr. Robinson, we'll see you on January 16th and January 30th at 1 p.m. Court is now in recess.
After reviewing every filing, every rebuttal, and every warning from law enforcement, the judge finally made a ruling. Tyler Robinson would be allowed to appear at his next hearing in street clothes. It wasn't a dramatic victory, but it was a meaningful one for the defense. For the first time in months, Robinson wouldn't walk into court marked by a jumpsuit and shackles. He would walk in looking at least on the surface like any other man. But the judge didn't close the door on the debate. Not even close. He made it clear that this ruling applied only to that hearing. Future appearances were still on the table. Security concerns still had to be addressed. And behind the scenes, more closed-door meetings were already being scheduled to decide whether this privilege could continue or be taken away. Robinson would be allowed to appear at his next hearing, not in chains, not in prison colors, but in clothes meant to soften the image of a man charged with murder. Yet the illusion was thin, because beneath the shirt and slacks was the full weight of the accusations against him. And surrounding him, just outside the camera's frame, were deputies watching every move he made. When news broke that Tyler Robinson would appear in court wearing street clothes, the reaction was immediate and explosive. Social media erupted. Supporters of Charlie Kirk were furious. Why give a killer special treatment? He should be in shackles, period. Comments flooded every platform. Outrage spread fast, but legal experts saw something different. They saw a constitutional stress test. Because if a defendant's clothing can sway public judgment, then where does the presumption of innocence actually begin? And where does it end? Some voices stepped in to remind the country of a hard truth. Even the most despised defendants, even the ones accused of the unthinkable, still deserve due process. That's not a loophole. That's the foundation of American justice. But the optics, They were impossible to ignore. A man accused of killing a national figure, walking into court unshackled, in clean clothes, with cameras capturing every step. It struck a nerve, a deep one, and in a nation already divided on politics, truth, and justice. This moment pushed the fracture line even further apart. When the day finally comes, the courtroom will fill fast. Reporters will pack the benches. Cameras will click. Sheriff's deputies will line the walls, shoulder to shoulder, a silent reminder of the stakes. And then, the room will fall still. Tyler Robinson will walk in. No shackles, no orange jumpsuit, just a plain shirt, dark pants, and the weight of every eye locked on him. The atmosphere will shift. Some will whisper. Most will stare, trying to reconcile the man in front of them with the headlines they've been reading for months. For a moment, just a moment, he may look like any other young man standing before a judge. And that is exactly the image his attorneys have fought to create. But behind him, the reality will remain unchanged. Deputies will stay tense, hands hovering near their belts, eyes tracking every move he makes. The clothes may be different, but the risk won't be. When the judge speaks, the message will likely be brief. The issue of attire is not settled, and future hearings may revisit the question. The matter will remain active and far from resolved. Legal analysts across the country started weighing in, because the implications reached far beyond a single Utah courtroom. If a judge ruled that jail clothing could unfairly shape public perception, and if that ruling held up, it could change how defendants appear in every pretrial hearing across America. This wasn't new territory. Even the US Supreme Court has spent decades wrestling with this exact tension. Security versus fairness. One legal analyst put it bluntly on national TV. The moment you see someone in jail clothing, your mind goes straight to guilty. And that's the core of the constitutional dilemma. Should the public's sense of safety outweigh a defendant's right to be seen as innocent? Or should the justice system absorb a little more risk to protect the principle that forms its very foundation? In this case, that question wasn't academic. It was unfolding in real time, and everyone was watching to see which side the scales of justice would favor. For now, the Tyler Robinson case continues, slowly, carefully, through hearings, motions, sealed documents, and guarded conversations. His actual trial may still be years away, but the fight over what he wears in the courtroom has already carved out a precedent of its own. Because this was never just about clothing. It was about the image of justice itself, and what happens when that image is forced to confront its own reflection. Is justice truly blind? Or does it react to color, fabric, metal, and fear? Lawyers will remember this motion. Deputies will remember it. Judges across the country will remember it. Because sometimes the smallest details, a shirt, a pair of slacks, a missing chain, a loosened shackle, expose the deepest truths about our legal system and about us. And in the end, the question remains, when a defendant walks into a courtroom, are we judging the person or the appearance? This case may decide that. If this story pulled you in, make sure you like the video, subscribe to EWU Crime, and turn on notifications so you never miss the next chapter in America's most chilling real-world cases. And tell us in the comments, should Tyler Robinson be allowed to appear in street clothes? Or should security take priority? Because in a courtroom, what a defendant wears can shape more than perception. It can change what justice looks like. Forever.